So why don't we get started? Just want to welcome everyone to the Hot Topic Lecture Series. I'm listed away, so I'm Kevin Jones, and I'm with our Institute for Energy Environment. For those who don't know me, so I'm standing in and doing some introductions. As everyone, most of you probably know, we have these lectures every Tuesday and Thursday, and they run through the first week of August. And COE credit is available. You just need to sign in an attendance roster, which you can back somewhere. It is a brown bag event, so those that are having an election feel welcome. And we will have short Q&A following the lecture. Today we're very honored to have with us Professor Anna Wiseman. Professor Wiseman is the Attorney's Title Professor at Florida State University College of Law, and her research explores the role of regulation protecting the character of living spaces and environmental quality from the sublocal to the national level. And Professor Wiseman teaches energy law, environmental law, and leads regulation. She has clerked for the Honorable Patrick Higginbotham at the U.S. Court of Appeals for the 5th Circuit, and she holds an A.B. summa cum laude from Dartmouth College, Florida, and a J.D. from Yale University. And today she's going to present on a topic that's, for those of us in the energy law area, are very excited to hear about disaggregating, preemption, and energy law. So welcome, Mr. Wiseman.
Thank you. Thanks for having me, and thanks for coming out on a beautiful summer day. I'm very happy to be in Vermont and not in Florida right now. I actually spend most of my summers in New Hampshire. I'm from New Hampshire originally, so but I do like Vermont. I think Vermont's prettier. So I don't know how much of Vermont New Hampshire rivalry all of you hold, but it's nice to be back, and thanks again for having me. I know this title is a little bit vague. I hope that I will somewhat quickly be able to explain to you the theme of my talk today in a simpler manner than the title presents. So what I view as a very current and important problem is that legislatures at the federal and state level, as well as judges that are interpreting legislation, to determine which level of government should control a particular area. Let's say energy. Should it be the federal government, the state government, or local government? Judges often are interpreting legislation to figure out who has jurisdiction. And often when either legislatures are deciding who has jurisdiction or judges are interpreting it, they take what I call an all or nothing approach. They say the federal government has complete control in this particular area, or the state government has complete control in this particular area. There's no room for local regulation. So, example would be oil and gas development. That's a particular regulatory area. It's a big activity right now, not in Vermont or New Hampshire. In parts of New England, it is a big activity, but some states are saying states should have full regulatory control over oil and gas development. Local governments get no say as to whether or not there should be a well, an oil or gas well within their jurisdiction. And I think this is the problem. I think giving one level of government almost full authority over an entire regulated area like oil and gas development can be dangerous from a variety of perspectives. I think that having multiple levels of government have a little bit of a say in that area provides local citizens with some say in what's happening within their jurisdiction. And then maybe including some state and federal perspective also helps. You know, people at the local level are very good at addressing land use concerns, nuisance concerns. Maybe the federal government knows more about the science of an activity and the environmental impacts, right? I think having several layers of government controlling a regulatory area can be beneficial, and that pushing out government can be a problem. And it also makes people mad when you tell them you have no regulatory control in this area. So in Vermont, now I have not followed Vermont wind energy regulation all that closely and focused more on other parts of the country, but my understanding is that in this state there has been a decent amount of controversy surrounding wind farms, especially on bridges. Correct me if I'm wrong about that. But wind farms are an important source of renewable energy, but they have environmental impacts. Transmission lines, aesthetic impacts, they do impact birds and bats, like other forms of energy development, right? And so I think especially when local governments feel that they don't have much say in the process for determining where a wind farm should go, how many wind turbines there should be, they can become frustrated. Same with oil and gas development. This is a photo from Denton, Texas, where the voters in Denton, Texas, a state you probably think of as oil and gas friendly, the voters in Denton said, we don't want hydraulic fracturing in our city. And they passed a resolution banning hydraulic fracturing. Then what did the state of Texas do? Preempted local control of oil and gas development, right? So local governments and citizens who live in towns and cities around the country get frustrated when they're pushed out of the regulatory process. And I'm going to use examples today in describing the preemption that's occurring. I'm going to use examples from 3 different areas of energy regulation, all of which I think are pretty important right now. Many of you might have heard about the incidents involving oil trains. There are lots of train cars carrying oil, largely from the Bakken Shale in North Dakota. The oil is being produced in large quantities in North Dakota due to hydraulic fracturing. There's not enough pipeline space. It's being moved by train car, and there have been some pretty dramatic incidents involving train cars derailing and exploding. The largest incident was in La Mégantic, Quebec, where 42 people died due to a train car derailing. In this energy context, the federal government has almost full control. State and local governments have almost no say over the regulation of trains, including oil trains, moving through their jurisdiction. And for all of you law students, you'd say, well, that sort of makes sense. It's classic commerce clause. You have a train moving through thousands of different local jurisdictions. If each city or town required different technology, it just wouldn't work. However, I think there's more room for local and state regulatory input in this area, but the federal government hasn't allowed it. In the oil and gas context, drilling and hydraulic fracturing for natural gas and oil, states have almost full control. The federal government, many of you have heard there are numerous exemptions from federal environmental laws for oil and gas development. And the federal government has also chosen to not impose much regulatory authority where it could. It just has not, the current administration has decided to sort of allow hydraulic fracturing to move forward without much federal regulation, with the exception of, I'd say, air regulation. There have been some pretty significant regulations on the methane emitted from oil and gas production. Those are under the Clean Air Act. Other than that, there hasn't been a lot of federal regulation. And then finally, renewable energy development. There's also a slight trend towards states wanting to control this area and to say, we the state should decide where a wind farm goes or where a solar farm goes. We don't want too much local intervention. However, the majority of states still allow local control over the siting of renewable energy. Sometimes it depends on the size of the renewable energy installation. The really big ones, it's primarily state control. But in a lot of states, local governments have more room to regulate in the renewable energy area. Okay, so some examples of the type of preemption that's occurring and pushing out certain governments from the regulatory area, which I think is a problem. So Texas and Oklahoma in 2015, this was in direct reaction to the Denton, Texas ban on hydraulic fracturing. Denton, Texas is near Oklahoma, so Oklahoma got worried that other local governments in Oklahoma would do something similar to Denton. And so both legislatures preempted most local control with some exceptions. the states tried to say we should have full authority over oil and gas development. In Ohio, we had a court interpreting state law. The Supreme Court of Ohio interpreted existing Ohio state law, has been on the books for a long time, to mean that local governments could not regulate hydraulic fracturing or oil and gas development. So in this case, a town in Ohio tried to say that before anyone drilled or fractured an oil and gas well, they had to get a permit from the town. They had to post a bond, a couple $1,000s, in case something went wrong and there was damage. And there were a couple other local requirements. The town wasn't banning oil and gas development, it was just trying to put a few conditions on it. And the Ohio Supreme Court looked at existing Ohio law and said, it looks like Ohio has a lot of regulations relating to oil and gas development, and it looks like these local regulations are conflicting with them. Therefore, we, the Ohio Supreme Court, are declaring that the local regulations in the town of Monroe Falls, Ohio, are preempted. In the renewable energy area, Ohio, once again, a culprit here, has preempted local regulatory authority over the siting of wind farms if they're greater than 5 megawatts in terms of how much electricity they might be able to produce. The state of Washington does not automatically preempt local decision-making with respect to wind energy, but it allows wind energy developers to go to the state and ask for preemption if they're having trouble at the local level. They can go to the Washington Energy Facility Site Evaluation Council and say, will you please approve our wind farm and supersede local control because we're having trouble siting it. And then, as I mentioned, in the rail context, it's mostly federal control. So the Federal Railroad Administration and the Pipeline and Hazardous Materials Safety Administration govern almost all transport of crude oil by rail. Okay, I'm going to argue that this shouldn't happen. We shouldn't have this broad preemption of regulatory control. We should not give just one level of government authority over a particular energy area. And when I talk about an energy area, I'm talking about oil and gas production or renewable energy development or crude oil transport. I'm arguing that we should look at these areas and recognize that there are lots of different types of regulation. This is what disaggregating or breaking apart regulation means. If you think about regulating a wind farm, there are lots of different ways in which we regulate wind farms. We regulate how strong the equipment has to be, the tower and the turbine and the cables holding up the tower. That might be a technological regulation. We regulate how loud the wind farm can be, the decibel level allowed near the site. There are also financial regulations relating to a wind farm. Bonding requirements. A lot of states say before you build a wind or solar farm, you have to put money down with the state in case you don't decommission it properly 20 years later. And you just leave all that equipment sitting there and it's dangerous. Also, there are a lot of taxes on energy development at the local, state, sometimes the federal level. So that's a different type of regulation within a broad area such as renewable energy or wind farm regulation. And land use, of course. We have to figure out where should the wind farm go. What zone is it allowed to be in? Are we going to allow commercial wind farms in residential zones? Probably not. How far should a wind farm be set back from houses? Also, the enforcement of the regulation. That's a different part of this broader regulatory area. Who should enforce all of the different types of regulations we have for wind farms? And any of you who are focusing on environmental law, you know this happens all the time. One level of government will often have the regulation on the books, and another level of government will enforce it, right? It happens a lot with most of our federal environmental laws. States implement the Clean Air Act, for example. And then there are a bunch of informational regulations. Before you construct a wind farm, you usually have to notify people nearby, and you have to do studies. and that's due to various regulatory requirements. My argument is, rather than saying, let's look at an entire regulatory area, such as regulation of renewable energy development, and decide that only the state should regulate, let's break down that area and recognize there are all sorts of different types of regulations, and maybe different governments could control different areas. Maybe local governments should have land use control because historically they have, and they're good at it. Maybe the federal or state government is better at knowing how a wind farm, how a wind tower and turbine should be constructed. Maybe there are experts at the federal or state level who would be better at regulating that in that area. So the idea is, let's have shared authority, or at least let's consider shared authority over these regulatory areas rather than just giving one level of government full control. Now, I'm not arguing that in all cases it's good to have all three different levels of government regulating. That can be too complicated, and in fact, it can cause gaps. Because sometimes if you give each of these governments some control, they don't recognize that there's an entire risky area that no one has addressed. But I think it's worth considering whether each of these levels of government should potentially control a particular regulatory area. So just here's an example. I'm not suggesting this is exactly how regulation should be shared among governments, but this would just be something to consider if we were thinking about wind farms. As I mentioned, maybe the state or even the federal government would be good at figuring out some of the technological regulations, as well as the operational aspects of wind farms that are sometimes important for protecting natural resources. So in some cases, if you shut down a wind farm during peak migration season or run it less, there's this feathering that you can do where the turbines don't run as much. This can reduce bird deaths. Maybe the state or the federal government has already done a lot of research in this area and is best at regulating in this area. Financial aspects, a lot of states already have this bonding requirement that I mentioned, where you put money down in order to show that you're going to properly decommission your wind farm. If you don't, there will be money available to do so. But local governments also have all sorts of bonding requirements, so maybe we should let them continue to be involved in this area as well. So in Texas, for example, a lot of local governments, before they were preempted, required oil and gas companies to put down a lot of money in case there were environmental damages. Fort Worth, Texas, Arlington, Texas, big cities that were worried about, they were allowing hydraulic fracturing oil and gas development to move forward, but they wanted to make sure that damages would be covered if damages occurred. Also, local governments are really good at implementing these agreements called community development agreements, where you work with a developer to try to provide benefits to cover the damages, the local damages that are occurring. Why not have local governments do that in the energy area as well, for wind farms and oil and gas development? Land use, nuisance-based regulation, again, I think local governments need some say in this area, probably enforcement. We could have state and local governments and federal governments all involved in this area. And then informational regulation, are we gonna require a wind farm developer to provide notice to all the neighbors? That would probably happen at the local level. Maybe the state is better at conducting environmental studies, but maybe the local government also has some expertise that should go into that study. So I hope you get the idea, and I don't even have much federal in here. I think the federal government can be involved in lots of these areas as well. This is just how I would hope a legislature or a court would approach a preemption question, rather than just saying, oh, we're talking about wind farm development, let's give states full control of it, right? I want them to think more about the fact that there are lots of different types of regulation. Why do this? How do I justify my proposal? Well, I think for one thing, if you look at the debate, the preemption debate, you often hear in broad political preemption debates, you'll hear members of the Federalist Society, which is a big legal, for those who aren't law students, a big legal organization that typically argues for state control, states' rights, etc. Federalists say it's good to have lower level control because state governments are more accountable to the citizens. They provide a diversity of perspective. If you don't like what one state does, you can move to another state. Now, they don't always go as far as to say local governments should also have that amount of control. But they have all these, the Federalists have all these values that they associate with states controlling regulatory areas, such as accountability to the people. But then then there's sort of the other side. Many people argue for federal control to avoid races to the bottom. If we have a federal regulation, states won't compete to be less environmentally protective, and so that's good, right? So there are these arguments on both sides for why we should have federal control versus state and local. I think the disaggregated approach might somewhat satisfy everyone. Now, of course, maybe it will just make everyone upset. But if you give the federal, state, and local government, you could give each of them a little bit of authority over different parts of a regulatory area, you're capturing some of the values that each of these sort of camps argue for, right? You're providing some local accountability because you have some state or local control over the issue. But if you have some federal involvement, you're also providing some federal oversight and hopefully avoiding problems like races to the bottom, where governments compete to be less environmentally protective. Also, I think if one level of government messes up, the other level of government might do a better job. So let's say a state had control over the financial aspects of regulatory areas, such as requiring bonds. You've got to post some money for your wind farm in case you don't decommission it properly. But then the bond regulation isn't very good, it doesn't work. Maybe if the local government was regulating in another area, the land use area, and saying, well, we want to make sure these wind farms are set back a decent amount from houses, it won't be as much of a problem if the wind farm is improperly decommissioned because you'll at least have some good land use. Right? So there's a possibility that if one level of government isn't doing a great job in its particular regulatory area, another will. And it will sort of balance each other out. I also think this would just, if we disaggregated the preemption approach, this would recognize what a lot of people have been saying in the literature. For those who aren't law students, you won't care about this. But there's this whole legal literature called sort of new federalism that argues this field called dual federalism, in which we're arguing about whether the federal government should control or we should have states' rights. There's a whole literature that says that's dead. I mean, if you really look at what's going on in reality, there are lots of areas where there is some local authority or state authority. Often there's shared federal and state control. There's cooperative federalism in the environmental context. Federalism is just not as simple as saying states' rights, federal control, and we need to recognize that. I also think this would make legislative and court decisions more transparent to people who are paying attention. When a court like the Supreme Court of Ohio says, we're not allowing any local control over oil and gas development, it's kind of like, wait, can you explain that more? Whereas if the Ohio Supreme Court had to go through these different parts of oil and gas regulation, land use based, financial, etc., and have to explain itself. Here's why we, the court, are deciding that all of these different areas should be at the state level. I think that would make the decision more approachable, and you could argue for or against the decision more easily because it would have been broken down. Okay, so let me just give a few I'm supposed to speak until 11:45. I might end early because I know it's lunchtime, you're all tired, you kind of want to ask questions. I think I won't go through all of these examples of why preemption doctrine already calls for this approach. I'll just give you a couple, and then I'll get into more of the recent regulations that I think either have disaggregated or have not disaggregated the preemption decision. Just very quickly, I think preemption doctrine, when courts go about deciding whether a state has in fact preempted local control, the doctrine there is already calling for disaggregation, and courts and legislatures just aren't doing it. And the reason I argue the doctrine is already calling for this type of disaggregation is when you look at the statutes in the energy area, they will often provide for a little bit of room for local, state, and federal control. So even though I said the federal government has almost full control over crude oil being transported by a train, there are exceptions. The Federal Rail Safety Act, which is the legislation providing for federal control, actually says if the federal government has not yet covered a particular regulatory area related to rail safety, local governments retain control. Now the problem is courts have interpreted federal coverage of rail safety really broadly. And so whenever local governments have tried to say, can we make a train go 2 miles away from a particular building that we think would be impacted by an oil spill, the courts have said, oh, that's already covered by federal law. So it's been hard for local governments to find any traction under the Federal Rail Safety Act. This act on its face at least appears to be asking for some sort of consideration of whether there's any room for local or state control. And then Texas, just one example from Texas and Oklahoma. Even though I said these states almost fully preempted local governments from regulating fracking, they actually recognize there's still a little bit of room for local governments, especially when it comes to emergency response, because who's the first person who comes out to an oil and gas site when there's an explosion or spill? It's the local fire department, the police department. And they recognize that and they said, okay, fine, local governments in Texas and Oklahoma can at least do that. They can regulate emergency response and a little bit of land use control. Local governments in Oklahoma and Texas are still allowed to determine the minimum distance between oil and gas well and a building. So they retain a little bit of land use authority. Okay, I'm just going to get to a few other examples of disaggregation. I'm not going to go through all this preemption doctrine. I'm going to give you examples of how some courts and legislatures have just kind of totally preempted, not allowing any room for local control, whereas others have started to disaggregate, as I hope they would. Here are some examples of courts taking the entire field and saying, only the state gets to regulate, or only the federal government gets to regulate. Back in 2005, this was a federal case, federal court interpreting state law. And the federal court said, when we, the court, look at Louisiana state oil and gas law, we think Louisiana has preempted all aspects of local regulation of oil and gas development, meaning that the city of Shreveport, which wanted to just set back oil and gas development 1,000 feet from its water supply, was preempted by the state. So there was no local land use control, there was just no local control. This is an example of all or nothing, full preemption, right? No disaggregation occurred here. And it's the same with the Ohio Supreme Court decision. The Ohio Supreme Court, I mentioned before, said City of Monroe Falls can't require a permit before an oil or gas well is drilled, can't require a bond. And I think the court was just wrong here. The court said the state also requires a bond, so there's conflict here. If the local government is requiring an oil and gas developer to put down $2,000 and the state is requiring some money as well, that's a conflict. Now, have any of you addressed conflict preemption in your classes? Is that really conflict? Is it impossible to comply with the local and state law? Not really, right? You can pay the bond, you can pay the $2,000 bond to the state, you can pay the additional bond to the local government. I don't view that as a direct conflict, but the court did. And so the court preempted all of the local control of oil and gas development. Okay, the dissent in this case would have disaggregated the preemption question. The dissent said, well, wait a minute. When we're talking about the regulation of oil and gas development, that's a massive field. There are different aspects of that regulation, including land use. And why can't the local government use its land use authority to regulate oil and gas, even if the state has other authority? And the majority in that case said, oh, that's fanciful. What are you talking about? This is preemptive. So it kind of rejected the disaggregation approach. Now, in other cases, courts and legislatures have started to recognize that there are different parts of a really big regulatory field, like oil and gas development or wind energy development, and different levels of government can have control over those fields. So many of you might have heard about the New York fracturing decisions. I'm not sure. New York is one of the few states that has determined that local governments may, in fact, ban oil and gas development using their land use authority, even though the state of New York has legislation on the books saying that local government regulation is preempted. So the state of New York has a really old law on the books that says local governments are preempted from regulating oil and gas development, but the highest court in New York said that doesn't mean their land use authority is preempted. Now that's all moot because the state of New York now does not allow high volume hydraulic fracture. What the New York courts did is they recognized that land use authority in a regulatory area is different from other types of authority, like technological regulations. And then I mentioned Oklahoma and Texas already. They allow limited, very limited land use authority over oil and gas development. Financial regulation. This is interesting. So Pennsylvania, as many of you also know, it's a big shale gas boom in Pennsylvania. And there was, of course, was the pipeline, I don't think the pipeline was going to go through Vermont. There was a big natural gas pipeline proposed from Pennsylvania's Marcellus Shale through New Hampshire and Massachusetts. I don't think it would have hit Vermont, but it was a big controversy. Anyway, in Pennsylvania, the state tried to say local governments have absolutely no authority over oil and gas regulation. They can't even zone for it. So the state of Pennsylvania passed an act that said local governments must allow oil and gas development even in residential zones. Now, this was later deemed unconstitutional by the Pennsylvania Supreme Court. But the interesting thing that the Pennsylvania legislature did when it preempted local land use authority is it said we are going to allow local governments to regulate financially. We're going to let them put a tax. They didn't use the word tax because it was unpopular. They called it an impact fee. We're going to let local governments, even though they have to allow oil and gas development, they can tax it. And they can use this money to address the damages that occur as a result of oil and gas development. I think this is an example of how, if you give different levels of government some authority in an area, it can kind of check the problems that occur at another level of government. So if the state of Pennsylvania does a really bad job of regulating oil and gas development, at least the local government has this money to address some of the damages. Now, that's not perfect. It's an ex post solution. Damages occur. Now we have some money to at least try to fix them, but it helps. Okay, Wisconsin. Do you remember I mentioned way back the state preempted most local control over wind energy development? They do allow local governments to require compensation to landowners nearby. So I believe in Vermont there have been some lawsuits by landowners wanting money as a result of the impacts from wind farms. But here in this case in Wisconsin, a local government can prevent landowners from having to go to court to get that money. They can just demand compensation for the impacts of the wind farm. Enforcement in the rail safety context, I'm jumping back and forth among different energy areas. But when we're talking about the transport of crude oil by rail, even though state and local governments are mostly preempted, they get to enforce rules that are the same as the federal regulations. What would be the point of that? Why give state and local government the authority to implement a rule that's identical to a federal law and then enforce it? Well, it's in case the federal government doesn't do the enforcement, right? So even though state and local governments can't put in place stricter laws regarding rail safety, they at least get to enforce the federal laws at the backup if the federal government doesn't do so. Okay, and then information-based regulation requiring notice to landowners, etc. When Oklahoma preempted local control of oil and gas development, it said local governments can still require disclosure. This is kind of minimum, but at least local governments can make the oil and gas developers say, there's going to be a well in your backyard soon, or near your backyard. Also, with respect to wind farms, Wisconsin lets local governments kind of monitor the wind energy developer and determine whether that developer has implemented various environmental mitigation measures required by another local government. So if the state or the federal governments come in and it said, in order to mitigate the impacts of this wind farm, you're going to have to stop operating it during peak bird migration season, local governments can at least monitor that and determine whether the wind energy developer is complying. Okay. I think that's enough. I'm going to stop a little bit early. I will mention that practically speaking, the effort to give different levels of government control within a regulatory area, I realize it's really resource intensive. It's not going to be easy to implement. Colorado tried to do this through something called an oil and gas task force. Colorado brought together all of these different levels of government and tried to get them to agree on who would control what. It didn't really work out. They fought a lot. They did reach some consensus, but they didn't reach consensus on the really meaty areas of oil and gas regulation, such as can local governments impose restrictions on the location of oil and gas wells? Or are local governments allowed to impose a fee on oil and gas development? The states and locals couldn't agree on that. So it's a difficult project, but I think it's a worthy project. And I think it's attempting to determine which level of government should control a particular part of a regulatory area is a lot better than just saying, we're not allowing this government to have any involvement in regulation. I think it's worth the resource-intensive effort. Okay, I've talked long enough. I welcome any questions you might have. No, that was kind of a lot.
So I understand that the desire to balance between local, state, federal interests. Where I think you're going to get pushback is that there's another balancing part, and that's from the industry. Saying, what about transactional efficiency and so on. So that's one point that I was just wondering what your thought were. And secondly, disaggregation, I'm not sure if that's equivalent or similar to subsidiarity. And subsidiarity, I think, really fits well with what you're talking about. I wonder if you have any thoughts on that.
Great question. So the first question, I think this would almost, it's almost certain the industry would oppose this proposal. I think would almost always result in more regulation. Not always, because I'm not arguing that substantively at the end of the preemption decision-making process, we're always going to have local, state, federal control, but I want legislatures and courts to think about that option. And if they're thinking about it, if they're required to at least consider the idea of breaking up, dividing this authority, the result is often going to be that there's more regulation at different levels, and that's tough for industry. I think that to address that concern, I would need to discuss more sort of how to put this in practice. Having some sort of oversight commission that coordinated the different levels of government and streamlined all of their different regulations so that the oil and gas or renewable energy developer could at least go through one entity that would do some of the sort of combining of all the different confusing regulations. That might help a bit. I'm sure industry would still oppose it.
I think they actually do that in Europe under the notion
Yes.
of subsidiarity.
That's right, and they do that a little bit in Washington State. I mentioned developers can ask for the state preemption process. In Washington, Oregon, the western states, there are these energy facility councils that are designed to centralize, to the extent there still is local control, they centralize the state and the local concerns. They streamline the process. I think it's more common in Europe. With respect to subsidiarity, in the longer underlying paper beneath this presentation, I discussed that a little bit, and I agree this is very similar to subsidiarity. Subsidiarity is the idea, it's more common in Europe, it's the idea that control over a particular regulatory area should be at the lowest possible level of government, because the governments are closest to the issue, know more, they're better regulated. Now, some subsidiarity scholars don't even say you should always go to the lowest level, they just say we should consider the fact that, yeah, they say something very similar to disaggregation. I think my proposal is different from subsidiarity. And in some cases, I think we really do need centralized federal control. After a court or a legislature looks at the different options, it will say, actually, in this case, we need something at a much higher level. And not as many subsidiarity scholars would say that. But I think there are many lessons to be drawn from that. Mainly European context. I think subsidiarity is sort of filtering into US law as well. Yeah, John.
Your talk makes, your excellent talk makes me think about hydropower regulation, where there's some sort of interesting contrasts and comparisons.
Yeah.
In hydropower, there's not only the vertical dimension, but there's a horizontal dimension. And there's a lot of dispute about, and it has been since the federal government organized itself to regulate hydropower 96 years ago, over whether or not the regulation ought to be concentrated in a single body like the Federal Power Commission, FERC, or whether the agency's jurisdiction of the sites of the projects, like the Forest Service or the Park Service, should have control. And that's been resolved in various ways. You can't build a project in a unit of the national park. You can in national forest lands. And the extent to which the Forest Service gets a say has varied over time. It's been a matter of continuing debate. It's a matter of debate as we speak.
Yeah.
On the vertical dimension, it's also interesting because the states do have a significant role, but in different ways, at different points in the process.
Yeah.
So
Water quality certification.
Section 401 water quality certification gives the states a very strong independent role with respect to water flows and impacts on fisheries, a lot of very important local environmental impacts. And then the Federal Power Act has a lot of provisions saying FERC has to give the locals an opportunity to weigh in.
Yeah.
They may have local plans, and those are entitled to some respect. They get to comment on the fish and wildlife restrictions, and their recommendations must be considered. Yeah. And so they're not only sort of substantive opportunities for locals to comment, but sort of procedural doors for them to offer their positions.
I like that point, and it reminds me, I'll go way back, this is going to take a while, but it'll be worth it. It reminds me on this slide, I should probably have a regional bubble. Now regional organizations don't always bring together, but when you talk about horizontal though, so when Professor Barrett mentions vertical and horizontal, we're talking about federal, state, local, but then also at each of these governance levels, you have multiple agencies with some sort of jurisdictional authority over a particular energy area. So you might have EPA, Forest Service, these are all federal entities. To what extent should they have jurisdictional authority as well? And sometimes you can use a regional organization to bring together lots of different agencies at a particular level. And so I should probably add that to my little graphic and think more about whether in the preemption question, legislatures and courts should be somehow required or encouraged to consider that horizontal aspect as well. And it sounds like you're suggesting hydropower might be a good example of some disaggregation vertically, is because of this local input that's required. I agree. I think it would be a really good case study. Another one I thought of that didn't really get into is the Coastal Zone Management Act. In terms of whenever an entity is proposing an energy or other form of development in a coastal area or offshore near state waters, states have more say than they often do in other types of federal decisions. States can say that a federally approved energy project in their coastal zone is not consistent with their land use and other planning for that zone. So that might be another interesting.
One local example of that, picking up on the comments, is often the way it works is that if there's a demonstration the locals have been thoughtful and adopted a plan, then they get to play. So in the Federal Power Act example, if there is a local plan for the management of the river that's been adopted by an appropriate authority, then that gets consideration in the coastal zone management context. If you have an approved coastal plan, the state has developed it, Commerce has signed off on it, then federal consistency applies. And now we have a new process here in Vermont that Kevin knows more about than anybody in the room, where local communities, if they adopt a energy siting plan, will then be able to require the Public Service Board to give due consideration to their planning determination once they got the plan.
Now, and is that part of Act 174? Does anyone want to weigh in on this? If this was just signed last week, does anyone want to further elaborate on this? Or we're gonna, okay. But yeah.
Go on.
Okay, yeah. My understanding is that Vermont is attempting to improve local input in the wind and solar siting context, but it sounds like it might be considered window or not enough, but there's some progress on that front, maybe. Any other comments, questions?
I got one over here.
Okay.
My preface is you could ask Professor Sharia how he fared with his disaggregation theory in the U.S. Supreme Court in California v. United States, because I helped write the brief. I think it was 8-zip, wasn't it?
So that was a prelude to that law to the prelude, but victory in PVD #1, but the Supreme Court upheld the 401 certification.
There we go.
So it's the back and forth over time.
Yeah.
But my question was, when you showed, and I apologize, I missed the beginning, so I may have missed the point, but when you showed your disaggregation model for wind power, that matched very exactly the kind of diligence I do on wind projects all the time. In other words, this is the existing state of affairs. Is that what, I couldn't know whether you were trying to wish that this is what should happen, or, because this looks a lot like what I see when I do diligence on a wind project in Oklahoma or Texas.
Right. For wind power, it's more so the existing state of affairs. Although some states have, as I view it, some states have preempted local governments more, but the majority of states still allow this. And in fact, many states, my understanding is most control is still at the local level. Texas, Oklahoma, especially, and Kansas local governments can fully ban a wind farm. Kansas Supreme Court, which might have gone too far toward one level of government, the local level having all control, right?
Yeah, because I
Yeah.
mean, if you're doing diligence on a project for a lender or a buyer,
Yes.
you get to ask all the tough questions, right? Because
Right.
you're in the catbird seat, right?
Yes.
And the
yes.
question usually is, have you complied with federal law?
Yeah.
You're gonna do all the fish and wildlife stuff. Have you complied with state law to the degree there is? And if you're in California, you've got CEQA, and that's a
Yeah.
nightmare, but
Yeah.
you've got to deal with it.
Yeah.
But most states do not have a comprehensive, maybe they should, but they don't
Right.
have one. So you're dealing with local zoning, if there is any.
Yeah.
And then you're dealing with just all the local land use requirements, which
Yeah.
might not be zoning, but
Right.
might be like whether you can have heavy trucks on the
Yeah.
highway and all that.
Yeah.
And then you'd say that is a disaggregated model.
Oh, yes, definitely. Oil and gas, it's not as much that way.
No, understood.
Right. But I agree there already is more disaggregation in the wind energy projects, which is why in the underlying paper, I give lots of examples of, look, in some areas this is already done. I don't include hydropower. I think it's a great idea to include it. More courts and legislatures could be doing this in other contexts, such as oil and gas, and they're not. Yeah. And I didn't include federal on here, but just because I was lazy. I agree the federal government still has quite a bit of input in wind farm decisions in particular, not as much in oil and gas.
Right, but typically on avian issues is what
Yes.
you're gonna get from
That-
the feds.
Yeah.
And defense issues from the defense agencies.
Right. And I guess the federal aviation, that's
Oh,
just a
FAA,
minor one,
yeah.
right? But yeah. Okay, other questions? Oh, wait, and
Maybe one more question.
quick question?
If not,
All right,
thank
thank you very much.